ChatGPT contracts, the basics. Elements of contracts. What are the basic elements of a contract? The basic elements of a contract are 1. Offer. An offer is a proposed agreement between two parties, which, if accepted, forms a binding contract. 2. Acceptance is the agreement by the offeree to the terms of the offer, creating a binding contract. 3. Consideration is something of value, either a promise or performance, given by one party in exchange for the promise of the other party. 4. Mutual agreement. Both parties must have a mutual understanding and agreement on the terms of the contract. 5. Capacity. Both parties must have the legal capacity to enter into the contract, meaning they are of legal age and have the mental capacity to understand the terms of the agreement. 6. Legality. The contract must not be for an illegal purpose or involve illegal activities. These elements must be present for a contract to be considered valid and enforceable. However, it is important to note that contracts can take many forms and can be written or verbal, formal or informal. Can you narrate the story of Carbolic Smoke Ball and explain the concepts of offer and acceptance in this case? The story of the Carbolic Smoke Ball Company is a famous legal case that illustrates the concepts of offer and acceptance in contract law. In the late 19th century, the Carbolic Smoke Ball Company advertised a product called the Carbolic Smoke Ball. The advertisement stated that if the ball was used according to the instructions, the user would not contract the flu. The advertisement also stated that the company would pay £100 to anyone who contracted the flu after using the product as directed. A woman named Mrs. Carlyle bought the Carbolic Smoke Ball and used it as directed. She subsequently contracted the flu and demanded the £100 reward promised in the advertisement. The Carbolic Smoke Ball Company refused to pay, arguing that the advertisement was not a binding offer, but merely a puff or sales talk. However, the court ruled in Mrs. Carlyle's favor and held that the advertisement constituted a binding offer. The court found that the clear and specific terms of the advertisement, the fact that the company had demonstrated its intention to be bound by the offer by depositing £1,000 in a bank account for the purpose of paying rewards, and the fact that Mrs. Carlyle had accepted the offer by performing the conditions set out in the advertisement, all combined to create a binding contract. The Carbolic Smoke Ball case is an important example of the principles of offer and acceptance in contract law. The advertisement by the company was considered an offer, which was accepted by Mrs. Carlyle when she bought and used the Carbolic Smoke Ball as directed. As a result, a binding contract was formed between the two parties, enforceable by the court. Can you imagine a few modern-day scenarios of Carbolic Smoke Ball in the context social media? Yes, here are a few modern-day scenarios that resemble the Carbolic Smoke Ball case in the context of social media. 1. A company offers a free trial of a new skincare product with the promise that if the user is not satisfied with the results, they will receive a full refund. The offer is posted on the company's social media page, and if a user takes advantage of the offer and is not satisfied with the results, they can claim the refund by contacting the company through a private message. 2. A popular influencer posts a sponsored tweet promoting a new exercise equipment and promises to pay $100 to anyone who follows the influencer's workout routine for a month and does not see results. If a user accepts the offer by following the routine and does not see results, they can contact the influencer through direct message to claim the $100 reward. 3. A restaurant posts a Facebook advertisement offering a discount on its signature dish for anyone who mentions the advertisement when ordering. If a customer accepts the offer by mentioning the advertisement and ordering the dish, the restaurant is bound to give the discount as promised. These scenarios demonstrate how the principles of offer and acceptance can be applied in modern-day situations involving social media. The advertisement or offer made on social media can create a binding contract if it is clear, specific, and accepted by the other party. Can you tell me about offer and acceptance in the case where a woman switched the price label on clothing at a store, was arrested for theft, and argued that she made a valid offer, which the clerk accepted? I'm not aware of a specific case that matches the description you provided. However, in general, the act of switching price labels on merchandise in a store would not be considered a valid offer, as it is illegal and goes against the store's policies. Offers in contract law must be made with the intention of creating a binding agreement and must comply with the law. Misrepresentation or fraud, such as switching price labels, is not a valid offer and does not create a binding contract. In this scenario, the woman's argument that she made a valid offer, which the clerk accepted, would not hold up in a court of law. The act of switching price labels does not create a valid offer, and the acceptance by the clerk does not make it a binding contract. The woman would likely still be held accountable for theft, as she obtained the merchandise through illegal means. While I agree with your conclusion, I am wondering how a store's internal policy can amount to creating a public crime. You raise a valid point. The internal policies of a store do not typically have the power to create a public crime. However, if the act of switching price labels is done with the intention of deceiving the store and obtaining merchandise through false representation, it could be considered theft or fraud, which are crimes under criminal law. In other words, the act of switching price labels may be illegal not because of the store's internal policy, but because it constitutes theft or fraud, which are offenses under the criminal law. The store's policy may be relevant as evidence of the intent of the person who switched the labels, but the policy itself would not create a crime. It's important to note that different jurisdictions have different laws regarding theft and fraud, and the specific circumstances of the case would need to be evaluated by a competent legal authority in order to determine the applicable law and the potential criminal or civil liabilities. Can you summarize a few more cases about the simple concept of offer, as an essential element of a contract? Sure. Here are a few more examples of cases that illustrate the concept of offer as an essential element of a contract. 1. Pharmaceutical Society of Great Britain v. Boots Cash Chemist Limited, 1953. This case involved the sale of prescription drugs in a chemist's shop. The court held that a display of goods in a shop window is not an offer, but an invitation to treat. An offer is only made when the customer approaches the counter and asks for the goods, and the acceptance occurs when the goods are handed over to the customer. 2. Gibson v. Manchester City Council, 1979. This case involved an advertisement by a local council for the sale of a property. The court held that the advertisement constituted an invitation to treat, not an offer. The council was only bound to sell the property to the highest bidder at a public auction, which was to be held at a later date. 3. Harvela Investments Limited v. Royal Trust of Canada, 1986. This case involved a letter of intent to purchase shares in a company. The court held that a letter of intent is not a binding contract, but merely an expression of the party's intention to enter into negotiations. The letter of intent did not constitute an offer because it was subject to further negotiation and the approval of the parties' respective boards. These cases demonstrate the importance of understanding the concept of offer in contract law. An offer must be clear, specific, and made with the intention of creating a binding agreement in order for a contract to be formed. In some cases, such as the display of goods in a shop window or a letter of intent, the expression may be considered an invitation to treat, not an offer, and not create a binding contract. Please explain invitation to treat with a couple of different examples, in a way that a 15-year-old can understand. Then please restate the conclusions of Boots Cash Chemist and Gibson, above, for a person who did not understand it before you provided the definition of invitation to treat. An invitation to treat is when a person or business shows something for sale or display, but it is not a final offer for a contract yet. It's like saying, hey, come take a look at this thing I have for sale, and maybe we can make a deal later. Here are a couple of examples to help illustrate the concept. 1. A grocery store displays food items in the shelves. This is an invitation to treat because the store is saying come take a look at these items and if you like something, we can make a deal. The actual offer is made when the customer takes an item to the cashier and attempts to pay for it. 2. An auction house displays items for sale and invites bids from the audience. This is also an invitation to treat because the auction house is saying come take a look at these items and if you want to bid on something, we can make a deal. The actual offer is made when a person makes a bid and the auctioneer accepts it. Regarding the cases of Boots Cash Chemist Limited and Gibson v. Manchester City Council. 1. Boots Cash Chemist Limited. In this case, the court ruled that the display of prescription drugs in a chemist's shop is not an offer, but an invitation to treat. An offer is only made when a customer approaches the counter and asks for the goods, and the acceptance occurs when the goods are handed over to the customer. 2. Gibson v. Manchester City Council. In this case, the court ruled that an advertisement by a local council for the sale of a property is not an offer, but an invitation to treat. The council was only bound to sell the property to the highest bidder at a public auction, which was to be held at a later date. The advertisement was simply an invitation for people to come take a look and possibly make an offer later. In these cases, the court ruled that the displays or advertisements were not final offers, but rather invitations to treat, and that a binding contract was only formed when the customer or bidder made an offer and the store or council accepted it. In modern contract negotiations, we have long contracts that people pass back and forth with comments. And there seems to be an implicit understanding that providing comments is not a rejection of the offer but simply a part of the negotiations. How does this practice of negotiation impact the principles of offer and acceptance? In modern contract negotiations, the process of exchanging contracts with comments and negotiating the terms of a contract can have an impact on the principles of offer and acceptance. The key to understanding the impact is to recognize that the exchange of comments and negotiations are not considered a rejection of the offer, but instead are part of the process of forming a contract. In this context, an offer is usually made in the form of a draft contract, which is then sent to the other party for review and comment. The other party may provide comments, suggestions, or request changes to the draft contract. This exchange of comments and negotiation of the terms of the contract are considered part of the process of forming a contract, rather than a rejection of the original offer. Once both parties have agreed on the terms of the contract, they sign the final document, which represents the acceptance of the offer and forms a binding agreement. The offer and acceptance can occur through the exchange of written documents or through conduct, such as by both parties performing their obligations under the contract. In conclusion, the principles of offer and acceptance still apply in modern contract negotiations. But the process of negotiating the terms of a contract through comments and changes to the draft contract is considered part of the process of forming a contract, rather than a rejection of the offer. The final signed document represents the acceptance of the offer and forms a binding agreement. But if someone makes a lot of comments or red lines on a draft contract, a person could fairly interpret these comments as a rejection of the contract and disengage. Yes, that's correct. If one party makes significant changes or red lines on a draft contract, it could reasonably be interpreted as a rejection of the offer and a signal that the negotiations have broken down. In such a case, the other party might disengage from the negotiations and look for a new opportunity to form a contract. It's important for both parties to clearly communicate their intentions and to reach a mutual understanding about the terms of the contract before accepting the offer. If one party makes substantial changes to the draft contract that are unacceptable to the other party, it's better to resolve the issues before proceeding with the negotiations. It's also worth noting that in some cases, the law may consider a series of negotiations over a period of time to be a rejection of an offer, even if the negotiations continued for a long time. The principle of reasonable expectation also comes into play here, as the law generally expects parties to communicate clearly and promptly in order to avoid confusion and misunderstandings. Explain the concept that acceptance must accept the terms of the offer unconditionally, with a couple of examples. The concept of unconditional acceptance means that in order for an acceptance of an offer to be effective, it must be made without any additions, modifications, or conditions. The acceptance must mirror the terms of the offer exactly, without any changes or qualifications. If the acceptance is made with any additions, modifications, or conditions, it is considered a counteroffer and is not an acceptance of the original offer. For example, consider the following scenario. A seller offers to sell a car for $10,000. The buyer accepts the offer, but adds the condition that the car must have a warranty. In this case, the buyer's acceptance is not an unconditional acceptance of the original offer, as it includes a new condition, the warranty requirement, that was not present in the original offer. Instead, it is considered a counteroffer and the seller may either accept or reject it. Another example is a landlord who offers to rent an apartment to a tenant for $1,000 per month. The tenant accepts the offer, but adds the condition that the rent will only be paid if the apartment is painted before they move in. In this case, the tenant's acceptance is not an unconditional acceptance of the original offer, as it includes a new condition, the painting requirement, that was not present in the original offer. Instead, it is considered a counteroffer and the landlord may either accept or reject it. In conclusion, for an acceptance of an offer to be effective, it must accept the terms of the offer unconditionally. If the acceptance includes any additions, modifications, or conditions, it is not considered an acceptance of the original offer, but instead is considered a counteroffer. And a counteroffer is a rejection of the offer. So what does that mean, with a few practical examples? Yes, that's correct. A counteroffer is a rejection of the original offer and a new offer in its own right. When a party makes a counteroffer, they are effectively rejecting the original offer and proposing new terms for the contract. For example, consider the following scenario. A seller offers to sell a car for $10,000. The buyer counteroffers with a price of $9,500. In this case, the buyer's counteroffer is a rejection of the original offer and a new offer in its own right, proposing a lower price of $9,500. The seller may either accept or reject the buyer's counteroffer. Another example is a landlord who offers to rent an apartment to a tenant for $1,000 per month. The tenant counteroffers with a request for the rent to be $950 per month. In this case, the tenant's counteroffer is a rejection of the original offer and a new offer in its own right, proposing a lower rent of $950 per month. The landlord may either accept or reject the tenant's counteroffer. In conclusion, a counteroffer is a rejection of the original offer and a new offer in its own right. The party making the counteroffer is proposing new terms for the contract, and the other party may either accept or reject these new terms. Can you tell me a case where a person made an offer and retracted the offer on the nick of time? Yes, one well-known case that demonstrates the principle of retracting an offer before it has been accepted is the case of Feldhaus v. Bindley. In this case, a man named Feldhaus made an offer to buy a horse from his nephew, Bindley. The offer was made in a letter and was never explicitly accepted by Bindley. However, Bindley took the horse to an auction and sold it to someone else. Feldhaus sued Bindley for breach of contract, claiming that Bindley had accepted his offer by taking the horse to the auction. The court ruled in favor of Bindley, stating that an offer can be retracted at any time before it has been accepted. In this case, because the offer was never explicitly accepted by Bindley, Feldhaus was free to retract it at any time before it was accepted. As a result, there was no enforceable contract between Feldhaus and Bindley was free to sell the horse to someone else. In conclusion, this case demonstrates that an offer can be retracted at any time before it has been accepted. Once an offer has been accepted, it becomes a binding contract, but before it has been accepted, it can be retracted by the person making the offer. So consideration means there have to be mutual promises, and if I promise to do something for nothing, and someone accepts, that would not be a binding contract? Yes, that's correct. Consideration is one of the essential elements of a contract, along with offer and acceptance. Consideration refers to something of value that is exchanged between the parties in a contract. It can be either a promise to do something or a promise not to do something. If there is no consideration involved, it means that there is no exchange of promises between the parties, and therefore, there is no contract. For example, if you promise to do something for someone without receiving anything in return, this is not considered a binding contract because there is no consideration involved. This means that, in general, contracts must involve mutual promises, where both parties promise to do something or not to do something in exchange for something else. If one party makes a promise to do something for nothing, and the other party accepts, this is not considered a binding contract because there is no consideration involved. In conclusion, consideration is an essential element of a contract, and it refers to something of value that is exchanged between the parties in a contract. A contract must involve mutual promises for there to be consideration and a binding contract. Can you explain the word consideration with reference to its diverse or consistent meanings? Often, people use the word consideration to mean they will think about it like, okay, I will consider that offer, but here, consideration means providing something valuable in exchange. Besides just thinking about it. Yes, you're correct. The word consideration can have different meanings in different contexts. In the context of contract law, consideration refers to something of value that is exchanged between the parties in a contract. It can be either a promise to do something or a promise not to do something. This consideration is what makes a contract binding, as it demonstrates that the parties have entered into a bargain, and both have agreed to do something in exchange for something else. However, in a more general sense, the word consideration can simply mean to think about something, take it into account, or give it thought. For example, when someone says I will consider your offer, they usually mean that they will think about it, weigh the pros and cons, and decide whether or not to accept it. In conclusion, the word consideration can have different meanings depending on the context in which it is used. In the context of contract law, it refers to something of value that is exchanged between the parties in a contract, whereas in a more general sense, it can simply mean to think about something. What about a promise to consider something? A promise to consider something is not considered valid consideration in contract law. Consideration in contract law refers to something of value that is exchanged between the parties in a contract. A promise to consider something does not meet this requirement as it does not involve the exchange of something of value. For example, if one party promises to consider entering into a contract with the other party, but does not make any specific commitment or promise to do something in exchange, this is not considered a binding contract. In order for a contract to be binding, there must be an exchange of promises or something of value. In conclusion, a promise to consider something is not considered valid consideration in contract law, as it does not involve the exchange of something of value. For a contract to be binding, there must be an exchange of promises or something of value between the parties. Can you outline a few cases illustrating the common law of mutual agreement or meeting of the minds? Yes, here are a few examples of cases that illustrate the concept of mutual agreement or meeting of the minds in common law. 1. Balfour v. Balfour, 1919. In this case, a husband promised to provide financial support to his wife while he was working abroad. The wife sued her husband for breach of contract when he failed to provide the promised support. The court ruled that there was no contract, as there was no consideration, something of value exchanged, and no intention to create a legally binding agreement. 2. Routledge v. Grant, 1828. In this case, a father promised to provide an annuity to his daughter if she married a certain man. The daughter married the man, but the father refused to provide the annuity. The court held that there was no contract because there was no meeting of the minds between the parties regarding the annuity. 3. Lucy v. Zemmer, 1954. In this case, two parties entered into a contract to sell a farm. One of the parties later claimed that the contract was a joke and not intended to be legally binding. The court held that a contract was formed because there was a meeting of the minds and an exchange of promises, even if one of the parties did not take the agreement seriously. These cases demonstrate that in order for a contract to be enforceable, there must be a meeting of the minds or mutual agreement between the parties regarding the terms of the contract. The parties must understand and agree to the terms of the contract, and intend for the agreement to be legally binding. How do courts typically solve the problem where one person says, "That is not what I meant," indicating that there was no meeting of the minds, if the promises are ambiguous? When the promises in a contract are ambiguous or unclear, and one party claims that there was no meeting of the minds, courts may use different approaches to resolve the issue. Here are a few methods that courts may use. 1. Interpretation of the contract. In some cases, the court will interpret the contract and determine the party's intent based on the language of the contract and the circumstances surrounding its formation. This can involve looking at any written or oral statements made by the parties, as well as any objective evidence of their intent. 2. Parole evidence rule. In some cases, the court may apply the parole evidence rule, which limits the introduction of evidence outside of the contract to show the party's intent. This means that the court will consider only the terms of the written contract and any contemporaneous written or oral statements made at the time of contracting. 3. Reformation of the contract. In some cases, the court may reform the contract to reflect the party's true intent. This may involve rewriting the contract to accurately reflect the party's agreement or setting aside the contract altogether. 4. Contract rescission. If the court finds that there was no meeting of the minds and no enforceable contract, it may allow one or both parties to rescind the contract and return to their original positions. In general, courts will try to determine the parties' intent based on the language of the contract, the circumstances surrounding its formation, and any other relevant evidence. The goal is to determine the parties' mutual agreement and resolve any disputes related to the terms of the contract. When someone gets a poor deal or a brunt end of the contract, they will typically say, "That is not what I thought we were agreeing to." Is there some degree of risk in not explaining the implications of a contract to the other side, assuming that they read the contract? Yes, there is a degree of risk in not explaining the implications of a contract to the other side and assuming that they will read and understand the contract on their own. This is because contracts can often be complex and filled with legal terms and concepts that are difficult to understand without proper explanation. If one party is not fully aware of the terms and implications of a contract, they may end up agreeing to terms that they did not intend to agree to or that are unfavorable to them. For this reason, it is important for parties to carefully review and understand the terms of a contract before signing it. If there is any ambiguity or uncertainty about the terms of the contract, it may be helpful to seek the advice of a legal professional or to negotiate the terms with the other party to ensure that the contract reflects the party's true intent. Additionally, it is also important for parties to communicate openly and honestly with each other during the contract negotiation process. This includes explaining any key terms or provisions that may be unclear, and making sure that both parties are on the same page regarding their obligations and expectations under the contract. This can help to reduce the risk of misunderstandings or disputes arising from the contract, because the purpose is to come to a real agreement. Then if something comes up, the party has to make good on their promise. Yes, that's correct. The purpose of a contract is to come to a real agreement between two parties. A contract is essentially a promise between two parties to do something or not do something, and each party is expected to fulfill their obligations under the contract. When a party makes a promise under a contract, they are accepting a legal obligation to fulfill that promise, and they can be held legally accountable if they fail to do so. This is why it's important for parties to take the time to carefully review and understand the terms of a contract before signing it. A well-written contract should clearly define the obligations of each party, and should provide a framework for resolving any disputes that may arise. By having a clear and enforceable agreement in place, both parties can feel confident that their rights and obligations will be protected, and that the other party will fulfill their obligations under the contract. Can you give me an ironic example of an illegal purpose or illegal activity in a contract where the contract was invalid? Sure, here's an example of an illegal purpose or illegal activity in a contract that renders the contract invalid. Imagine that two people enter into a contract for one person to sell illegal drugs to the other person. Even though both parties have agreed to the terms of the contract is illegal because it involves illegal activity, selling drugs. As a result, the contract is unenforceable, and neither party can take legal action to enforce the contract if the other party fails to fulfill their obligations. This example highlights the principle that contracts that involve illegal activities are considered illegal and unenforceable. In general, a contract is considered illegal if its purpose or the activities required to fulfill the contract violate the law. This can include contracts for illegal goods or services, contracts that require a party to perform illegal acts, and contracts that are against public policy. In these cases, the contract is considered void and unenforceable from the start. But drug dealers must still pay taxes on their earnings. While it's true that drug dealers are required to pay taxes on their illegal income, the fact remains that their activities are illegal and therefore the contracts they enter into in connection with those activities are also illegal. In general, the fact that someone is required to pay taxes on illegal income does not make the underlying illegal activity legal or the contracts related to that activity enforceable. In the United States, for example, the Internal Revenue Service requires individuals and businesses to report all of their income, including illegal income, on their tax returns. Failure to report illegal income can result in significant fines and penalties, and even criminal charges in some cases. However, this requirement to pay taxes does not make the underlying illegal activity legal or the contracts related to that activity enforceable. The purpose of requiring individuals and businesses to report all of their income, including illegal income, is to ensure that the government receives the tax revenue that it is owed, not to make illegal activities legal. Can you give me a different example of a contract that is unenforceable for legality, where one person already fulfilled their promises and the other person did not have to fulfill their promises? Certainly. A classic example of an unenforceable contract due to legality is a contract for illegal activity. For example, if two individuals enter into a contract to purchase and sell stolen goods, the contract would be illegal and unenforceable because it involves the sale of stolen property, which is illegal. Even if one of the parties has fulfilled their obligations under the contract would still be unenforceable because the purpose of the contract is illegal. This means that the party who fulfilled their obligations would not be able to sue the other party to enforce the contract, and the other party would not be obligated to fulfill their obligations under the contract. This is an example of a contract that is unenforceable due to its illegality, regardless of whether one party has fulfilled their obligations. The general principle is that contracts for illegal purposes are unenforceable and courts will not enforce them. How would you analyze this situation? John posts online, "I will give $1 million to the first person who emails me." The first person who emails John did not read the offer online, but the second person who emailed John did read the offer. To analyze this situation, we would need to examine the elements of a contract to determine if a binding agreement was formed between John and the first person who emailed him. In order for a contract to be formed, there must be an offer, acceptance, and consideration. An offer is a clear and definite statement by one party indicating their willingness to enter into a contract on certain terms. In this case, John's statement that "I will give $1 million to the first person who emails me" could be considered an offer. Acceptance occurs when the offeree communicates their assent to the terms of the offer. In this situation, the first person who emailed John did not read the offer, so they were not aware of the terms of John's offer. Therefore, they could not have accepted the offer and no contract was formed. The second person who emailed John read the offer, and by sending an email they communicated their assent to the terms of the offer. This would be considered acceptance and a contract would be formed between John and the second person. In conclusion, the analysis of this situation would depend on whether the first person who emailed John read the offer or not. If they did not read the offer, then no contract was formed. If they did read the offer, then a contract was formed between John and the first person who emailed him.